The second day of bankruptcy hearings for Celsius Network is currently underway. Counsel for Celsius laid out a hopeful plan to recover customer assets and cited the recent crypto markets rally as increasing the value of recoverable funds, potentially. Meanwhile, Celsius is set to run out of cash by October, according to court filings. Celsius filed for bankruptcy protection in July, and they're short of $2.8 billion in crypto assets, the court filing reveals. Joining us now to discuss is Thad Wilson. He's a partner at law firm King and Spalding LLP. Welcome to the show, Thad. So I know you've been listening to the hearing and you specialize in Chapter 11 bankruptcy. So I'd love to hear your key thoughts so far.
Well, thanks for having me on this afternoon, Christine. Really appreciate you having me on. So I think the initial reaction to the hearing so far today is that I think the path here is going to be long and arduous for Celsius to otherwise emerge from Chapter 11. There are a lot of novel questions that are being raised by this bankruptcy case. There's a lot of interest in the bankruptcy case, both from customers, the media, and other constituents. As we heard during the hearing already, the committee for the customers was recently appointed. And as of right now, everyone seems to be holding hands. But I would predict for you today that once the investigations heat up both internally at the company as well as with the committee of customers, that all bets are off. And I think in particular, when you overlay the regulatory investigations that are ongoing, that were alluded to during today's hearing, that it's going to make the situation substantially more complicated for all the parties.
We also heard there were two ad hoc committees, and one was representing the custody holders. So how do all these committees interact with one another?
That's a very great question, Christine. So the committees in a normal bankruptcy case are responsible for representing various constituencies, and it's not unheard of for there to be multiple different committees that are established in a normal bankruptcy case. Here you've got various and disparate interests from the various committees, including the Committee of Customer Account Holders. You have the custodial account holders and what they call the withhold account holders. And so each of them have very different interests today during the hearing. Certainly some of them believe that their interests can be treated differently than others. And so that's why you have this, series of different committees that have been established or organized or formed. The ad hoc committees are informal committees. That's, pretty standard in a bankruptcy case. And that ad hoc committee is otherwise going to try to leverage whatever settlement it can for the benefit of the people that it represents. So, as far as the really kind of interesting thing, at least so far in the hearing from my perspective, you had Judge Glenn mention that he's concerned about the custodial account holders and whether or not those custodial accounts were really set up for the benefit of insiders. That might be the most significant news that we've heard so far today, other than the major cash and liquidity issues that Celsius finds itself in. And the shortfall of liquidity at really a very near-term perspective in October.
When you say insiders, is that for the higher-ups of Celsius, internal staff, or within a group that was, I suppose, amicable or amiable in working with Celsius as custody holders?
Yeah, so insiders are not defined in the bankruptcy code, Christine, but they're typically thought of as, officers, directors of the company, also, significant shareholders of the company. Insiders are kind of held to a different standard under the bankruptcy code in terms of the way that, various claims and causes of action that arise under the bankruptcy code occur, and how that litigation might be brought against them over time. So I did think it was of note that Judge Glenn had focused in as to whether or not, the insiders here, the management team, significant shareholders set up these custody accounts potentially to benefit themselves. That was the judge's question. He just noted it for the record. He wasn't saying that there were issues there or not, but he was certainly raising a concern there.
Certainly interesting. So Celsius's attorney laid out a path forward for the company, and it involves, engaging with the committee and other stakeholders to reach consensus on key plan terms. There will be a plan formulation and negotiation. They will file the plan, make various disclosures. Does this sound all above board to you? And in terms of a timeline, is it efficient?
Yeah, so a really good question, Christine. And for those unfamiliar with the bankruptcy process, this is the way that it plays out. I mean, this is the template that Mr. Sussberg laid out on behalf of the Celsius debtors is no different than it would be in any other case. Normally, you have a negotiation period. You have a period where a plan is negotiated, otherwise written up and put forth in front of creditors for a vote. And that process takes time. Interestingly, the debtors did not, in this case, outline what they believe that timeline should be in terms of the number of days, months, or even years. Like I said at the outset, I think that the path here is going to be a lengthy one. It's going to involve a substantial amount of litigation by various creditor constituencies and other parties. There might even be regulatory actions that either are brought inside or outside of the bankruptcy case. So I think that it's going to be a touch and go situation in terms of the timeline, particularly in light of the funding issues, because whether or not Celsius is ultimately going to be able to reorganize is going to depend a lot on what happens in the next 60 to 90 days. We don't know who the DIP funding parties are going to be, or how Celsius is going to be able to manage to survive with the cash constraints that it's under. What is the collateral that's going to be the source of the pledge that is going to be needed to obtain or secure that DIP financing? Or is there another source of financing that might be able to come to bear? And how is Celsius going to repay that financing? I mean, it's certainly a significant issue that the debtors are going to have to face and come to terms with over the course of the next 60 or 90 days, and one that I think everyone is going to be laser focused on in the very near term.
Funny you should say. The judge also cited an article that CoinDesk has written about, which is that Celsius holds $2.8 billion less in crypto than what it owes to the depositors. So how are they going to return funds given this sizable gap?
I think that's the $1 million question, Christine. How the debtors are able to close a $2+ billion gap is a significant one. I think we heard the counsel to the committee at today's hearing, the customer committee that is, say that they anticipate that funding gap may be closed, and they're going to try to make customers whole through providing Celsius specific coins. But in terms of the invested coins, I think the only way that there's a ultimate recovery at 100% level here is if the value of the underlying collateral, in this case, the Bitcoin, the Ether, and other crypto, ultimately goes back up in value and by a pretty substantial margin.
This lawyer for Celsius mentioned that they are receiving calls, letters from hundreds, thousands of people who customers with that have lost assets, and they're trying to recover them. They're getting a lot of comments that Celsius is profiting from their restructuring that they're planning, and the lawyer for Celsius was saying that is not true. But I'd like to hear your take on that.
Yeah, I don't really have a view on that, Christine, one way or another. I think it's an open question. I think that the committee for the customers, as well as the ad hoc committees, are going to be taking a very close look at that. I think you'll see the U.S. Trustee's Office also taking a keen interest in that from the standpoint of whether or not they're going to allow a debtor to profit off the backs of customer holders. I think those remain to be very serious allegations, and ones that, at least according to the counsel for the customer committee, are going to be investigated, and they're going to leave no stone unturned.